Hello, friends. Today we are going to discuss Arnab Goswami matter, which is currently in the news, and this matter has got relevance for today's discussion, and we'll see how because it has got a very important criminal issue involved in it. So let's start with the discussion. Let me share my presentation. Okay, so here we are. All right. Okay, so as I mentioned, we are going to discuss Arnab Goswami bail matter. Okay, why we chose this topic? Because it is in the news and it involves extremely important issue of criminal law, and the matter is still in the court and issue is not yet resolved. However, we are not going to discuss freedom of press, freedom of expression versus state power, and all other issues that try to color the moot point of law. Now, what is issue one? Whether habeas corpus plea is tenable in a remand. Arnab Goswami was arrested by Raigad police in 2018 case of abetment of suicide and was sent to a judicial custody. He filed a habeas corpus petition under Article 226 on the ground the arrest was illegal. His contention was that the police has filed a closure report and without permission of magistrate police had reopened the case and effected arrest. Supreme Court in now we'll see these three cases of the Supreme Court which are very important in this particular issue. One is Supreme Court in Home Secretary Prison versus H. Nilofer Nisha, which is a 2020 case, very important case, held that read under habeas corpus does not lie in cases where accused is in lawful custody. Then the second case is by Supreme Court on Sadhvi Pragya Thakur, which held that right under Article 22, Subclause 2 lies against illegal detention by police and not against a person in judicial custody pursuant to a court order. In Chagan Bhujlal case, the court held that even if it was assumed that the arrest was illegal, if a court has ordered for remand by a judicial order by proper application of mind, then right of habeas corpus does not lie. So these three cases are very important. Now we'll see what has happened in the present case. In the present case, Arnab Goswami was remanded to judicial custody by a judicial magistrate by a judicial order. Hence, the ratio of the above judgments apply and remedy of habeas corpus does not lie. But what if the remand order itself is prima facie illegal? The court will decide upon it shortly. Okay. So now what is the issue two? Can police reopen a case without permission of magistrate after submission of closure report? Now in the present instance, the closure report was submitted by the police, which was accepted by the court. However, the complainant, as per the reports, was not intimated of this fact and she was devoid of the opportunity to file a protest petition. Police reopened the case and effected arrest. Now we need to know certain provisions and few cases to understand the issue too. First being Section 173 subclause 8 of CRPC empowers a police officer to conduct further investigation and send another report to the magistrate after final form is submitted under Section 173 subclause 2 of CRPC. Second being Ramlal Narang versus State, which is a 1979 case, a landmark case in which the court had held that the police should seek permission, a formal permission from the court before investigation upon a fresh fact. And third being, however, in Hassanbhai Vallabhbhai Qureshi versus State of Gujarat, the court held that subsection 8 of Section 173 of the code permits further investigation and even dehors any direction from the court as such. Now, this is a very important case, a recent important case. in which is Vinubhai Haribhai Malviya versus State of Gujarat, in which the Supreme Court held that to say that a fair and just investigation would lead to the conclusion that the police retain the power, subject of course to the magistrate's nod under section 173(8) to further investigate an offence till charges are framed. So what is the correct position of law now? CRPC does not speak about any express permission from the court. Another way of looking at it, okay, if police has filed a final form to court with an express prayer, this is very important, with an express prayer included in the closure report to keep investigation open under section 173(8) of CRPC, and if the court has approved the closure report, then there is no express permission required to further investigate. However, the matter will be decided in next week by Bombay High Court. Thank you guys, and we will, once the judgment is out, we will analyze this in detail for our regular class students. Till then, bye bye.